also good. But what we're going to be talking about is the material that you have in front of you. And so you take that with you as a handout and take it back to your office. There are a couple of things, though, I want you to know. If you do want to take the 90 miles to Houston, there's a free CLE that's going to be on March the 12th. So there's a doctor in Houston by the name of Lucky Chopra. Lucky's a really good guy, has a really incredible medical practice, and besides being a good doctor, he's also a good businessman. And he has like 3 or 4 restaurants in Houston, and one of them is a place called Mr. Peebles, P-E-E-B-L-E-S, Mr. Peebles. And at that restaurant, he likes to have, especially people that do PI, because he then tries to get those attorneys, obviously, to send the clients to his diagnostic clinics. And so each year now, he's put on a what's called the Advanced Healthcare Seminar for PI trial attorneys. And there's about 6 hours of credit, CLE, and 1 hour of ethics. And the good thing about that is that it's free. And so if you want to drive to Houston on, I think that's Thursday, March the 12th, there will be this CLE program put on, and we've had some really fine speakers come and speak for that. We'll have a good lineup on that Thursday too. So if you do any PI or know somebody that does, you just might keep that in mind. I want to plug that for you. Okay, so what we're going to talk about today is the material in your handout, and talk about 3 different cases, and really talk about what happens if there is a fee dispute with a client. The first case we'll be talking about is one involving Patrick Smitherman, and his case involved Rule 1.14, safeguarding property, of what to do if you get a settlement check in, and there's an issue of whether you think the fee is disputed or not, and what your obligations with that. We're going to go in much more detail about this, but basically what happened to Mr. Smitherman is that he got a large settlement, about $500,000. He had a contract with his client. That contract is one of the items there in your material. So you can see the contract that he put together compared to your contract and see whether you want to change things or not. But in settling the case, he knew from the beginning with this particular client that there was going to be a dispute. There was going to be problems. They had been longtime friends and longtime enemies and longtime somewhere in between. And so when the settlement check hit, Patrick wrote a check to his father, who's one of the clients, wrote a check to himself as the attorney, and then notified Mr. Perry immediately that the money had been received, gave him accounting, and said, you know as well as I do that we agreed that there would be a bonus. And that's an important point, because there's never been a dispute that there was a bonus to be paid. Exactly how much that bonus would be was an issue. Then what happened, and all this is all pretty well factually driven, the client went out and got another attorney, wrote a letter to Smitherman saying, you need to pay me, and if you don't pay me immediately, I'm going to sue you and your firm. I'm sorry, I'm going to sue you personally. Not even saying as a firm. The contract was with the firm. I'm going to sue you personally. Mr. Smitherman took that to mean that all the settlement, the $200,000 or so, that was to be paid to the client was in dispute. And since it was in dispute, under Rule 1.14, he kept it into a trust account until about a year later there was a arbitration, resolution, a settlement. During this negotiations, the client contacted this attorney, as I said, and the attorney got him to file a grievance against Mr. Smitherman. And it was the bar's position that because there were some emails talking about what was disputed and what wasn't disputed, that the money that was not disputed should have been paid immediately to the client, and then you could held the rest of it out. So that's kind of the factual context of this case. What's also sort of interesting about this case is procedurally, both the Office of Chief Disciplinary Counsel and the judge appointed to the case, for whatever reason, dragged this case out for about 3 years. And when it finally went to trial, Smitherman himself, as a pro se attorney, tried the case to a jury. And the two jury issues that were presented there were both ruled, the decision was in favor of Mr. Smitherman. So you think that, well, the facts were there, jury was right, we won. Well, lo and behold, the disciplinary counsel by the name of Tim Burrish filed a judgment in OB. The court granted it. Mr. Smitherman then, having been found guilty of professional misconduct by the judge, had to go next to a sanctions hearing. The judge apparently didn't like Mr. Smitherman and gave him 2 years suspended of a 3-year sentence. Luckily, that case could be appealed, and so he stayed that sentence, and that case is now on appeal. We'll talk about maybe what could have been done differently in that particular case, but that is an interesting situation where there is a dispute over amount, and what does that mean there is a dispute? And if the client says, if you don't pay me immediately, I'm going to sue you for all the amount, I don't care if you had any attorney's fees, does that then kick it into the arena of a total dispute, and so you don't have to pay him anything until some resolution? The other interesting part about this is that there is actually a guideline to handling trust accounts. It's called the State Bar Client Trust Fund Brochure. And in that brochure it says that if the attorney pays the amount when it's not clear as to who the owner is, you do so at your own risk. That's great. I want to say first, if anybody has a question, given the smallness of the group and given the intimacy here, if you do have a question at any point, please ask it. Now, I'm sorry, tell me your name again. Dan.
My question is, where can I get this brochure?
Well, you go to the State Bar site, and it's right there, and the name of that is State Bar of Texas.
Is the trust account information or something?
Yeah.
I never did.
It's okay. Here, so if you want to write this down, I don't know whether I put it in the material. I don't think I did. It's called A Lawyer's Guide to Client Trust Accounts. A Lawyer's Guide to Trust Accounts. And it says specifically, if it is unclear to whom the funds belong or a dispute among claimants exists, then a lawyer pays, and this is the language out of this State Bar document, a lawyer pays at his own peril. A lawyer should not assume the role of deciding fund ownership in the case of dispute, whether the dispute exists between the client and a third party or between the client and the lawyer. Okay, so according to this brochure, if there is uncertainty as to how much is owed, whether it's in dispute or not, whether it's real clear as to the amount or not, whether there's a third party involved, you have the responsibility to hold on to those funds until it's resolved. Now, in the case of Mr. Smitherman, what's interesting is that there was an arbitration agreement, and that paragraph is in the material you have in the Smitherman contract. So Smitherman was saying, well, you're trying to sue me for the amount. We have a dispute here. We have an arbitration agreement. I'm going to wait until we go with the arbitration agreement. Well, that wasn't the position of the Office of Chief Disciplinary Counsel. What's also interesting about this is that given all this hullabaloo that was going on, neither the Office of Chief Disciplinary Counsel in the Smitherman case nor Mr. Smitherman used an expert witness. Okay? So the jury did not have the guide of someone who could say, well, this is the way that rule's interpreted, or talk about what an attorney's responsibilities were. I think that was a mistake. So let me back up to two things that you can do in a situation before the grievance gets filed. Hopefully, given again, that will never happen to you, but sometimes, this probably has never happened to any attorney in this room, you have a dispute with a client over something. Maybe that's only happens in Houston or in Dallas. But if that happens, there are a couple of things prophylactically you can do. Number one, you can call the Ethics Hotline for the State Bar of Texas. Well, I called the State Bar Ethics Hotline, 800 number, and they will not give me a written opinion. So what do I do about that to document it? Well, there are two things. Number one, regardless of them not giving you a written opinion, you can obviously put a memo to the file. On February the 4th, I talked to the State Bar Ethics opinion and was told this. Or another way to do it is to simply send an email to the State Bar. I talked to the ethics opinion, and for some reason, the last person I talked to up there was a woman, I can't remember her name, but she's there 8 hours a day, and she advised me this way about what was going on. So that's, again, something that you can do to protect yourself that I tried to find out. I called the State Bar, I got this opinion, I made a memo of it. There is also what's called the State Bar of Texas Ethics Committee, and you see those opinions come out in State Bar Journal, and you wonder how those get there. And if you have maybe 2 or 3 years to wait for an opinion, you can get an opinion there. And of course, the final resolution is to call someone like Bob Shewart and Lillian Hardwick, who actually wrote textbooks about this, and you can even call Bob Bennett, for whatever that's worth. So those are some ways when you're dealing with a fee dispute that you can know how to protect yourself and make sure that this doesn't get to the level. If the bar sends you the ominous letter that a complaint has been filed against you and wants you to respond, in that response you can say, 1, I try to explain this to my client. 2, I call the ethics hotline. 3, this is the memo that I wrote giving the information about what I should do with these funds. So all that is something that if you have an issue or you see, I've had clients who say, well, why should you get any of this PI settlement because all the money was mine and you didn't have to go to trial. Well, I know I signed a contract with you, but et cetera, I want all the money. So, a situation like that or modifications like that or a situation where you're negotiating to try to get the fee the way you want it, all those are ways to approach that. So, a letter about the Smitherman case is included in that material, and hopefully you'll find that helpful. The document, again, is the State Bar of Texas Lawyer's Guide to Client Trust Accounts. It's on the website. Just go there and look it up if you have a question. Okay, so that's a little capsule of the Smitherman case. The next case is the case involving Clarissa Ricardo. And Clarissa Ricardo was an attorney that does mainly an immigration practice. And in that practice, she had a client who came across the border to marry an American citizen. They stopped her at the border. She had a lot of money with her. There was a question about what her true intent was. Was she trying to come in on a visa that then she was going to get married and stay? She made a lot of statements when she was stopped by the Customs and Border Patrol, and she was sent back to Mexico. Her fiance then went out and hired Clarissa Ricardo to represent him and her and try to get her status changed. Okay, so that's the start of the Clarissa Ricardo case. There was a $5,000 retainer paid. Clarissa started working on the case. Unfortunately, there was no contract signed giving the scope of the representation. And that might be the first concern, that there was no contract as to what services were to be rendered. As they proceeded with the case, Clarissa, who's an experienced immigration attorney, decided that what was necessary was to file a habeas corpus action. And again, I don't do immigration, but it's my understanding that has to be filed in Washington, D.C. She took some of the funds, filed it in Washington, D.C., tried to find local counsel, tried to get something done. That proved to be not fruitful. It didn't work out, even though the purpose of that was trying to suppress the statements of her client made when she was arrested coming to the United States. There were some funds left over that she then took these funds and applied them to other activities with the case. So there was some money that was in the trust account. After the money was used, she then billed some more funds to the client. The client paid those. About a year and a half went by, no action was taken, and the client finally terminated her and said, if you don't give me all my money back, I'm going to file a grievance against you. Clarissa said, I did everything I was supposed to. I tried to get you a status. It didn't work out. I'm still working on it, but I'm not going to give you any money back. Grievance was filed, and then the position of the bar was that you didn't have permission of the client to take these monies and use them to do this habeas corpus. And that was the basis of their finding that there was a Rule 115D violation, refunding of any advance payments of fee that had not been earned. Now, I see this as an incredible stretch, but that case went to a jury trial in Houston after the Office of Chief Disciplinary Counsel put on their case. The judge instructed a verdict and for Ms. Guajardo, and in that case, the Office of Chief Disciplinary Counsel appealed the case, and the decision is in materials here. The Court of Appeals upheld that. So that had, the case we've been talking about, ultimately a very good outcome. Of course, the issue then is that Clarissa had to spend hiring an attorney, spent in 6 figures to have representation, and of course under our present bar rules, there's no way that she can be reimbursed for getting that money back, even though she won the case. So the bottom line on that case were the 2 things. Number one, if she had had a contract that specifically said everything that we do in pursuant of trying to get the status changed will be part of the services rendered, or phraseology like that would have been helpful. Second, there apparently was there was a lack of communication explaining to the client why she was doing the habeas corpus, what was going to happen to the funds, how the funds were going to be used, and the client was not made knowledgeable, even though the client had approved doing anything that was necessary to get the status change of the fiancé.